Hi, Derek here of McKenzie Friend Consultants. Welcome back. In today's short video, I'm going to cover an extremely important part in financial settlement cases, and that is making your financial settlement offer. Why is this so important? Quite simply put, the effectiveness of your offer can make or break the outcome of your financial statement. Now that is pretty damned important. It is something that many people get very wrong, and making ineffective offers can prove to be very expensive indeed. So, what is your financial settlement offer? It's basically an offer that you make to your ex in an attempt to reach a final agreement so that you can both move on and get on with your lives. Now, just before I move on with this video, can you please hit the subscribe button below so that you don't miss any of my must-watch videos. So, when do you make your financial settlement offer? Well, you can make your offer at any time during the proceedings. However, there are also times when you must make your offer, which I'll cover a little later. When is the earliest time to make an offer? Well, offers are frequently made by one party or the other before proceedings start in an attempt to avoid the court process, which is a very good idea, as it could save you lots of stress and money, particularly if you're using those outrageously expensive family lawyers. Now, I often get calls from distressed people saying that I've just received a letter from my ex's solicitor making me an offer for a financial settlement, and that if I don't accept it, then they will start proceedings against me. It states that I will not get a better outcome in the court process, and that I will also have to pay their costs. Well, these unscrupulous family lawyers should be totally ashamed of themselves by sending such a bullying letter. However, they do this on a routine basis and are, in quotes, just doing their job. Well, let's take a look at this wonderful letter. Firstly, the offer in the letter will almost certainly be heavily weighted in their client's interest and not really worth consideration. They will not be taking you to court. They will simply be making an application to court for a financial remedy, and this will involve both parties' participation. It is merely a process. Now, the offer made will not be fair and reasonable, and as such, you will almost certainly get a far better outcome if you did go through the court process. And finally, it is very rare to award costs in family court proceedings, and they are only awarded if one party has been totally unreasonable and incurred significant additional costs for the other party as a result. Not agreeing to their offer does not remotely amount to a party being unreasonable, and their claim of being awarded costs is simply an unfair, outlandish bullying tactic. I will suggest that you simply file this letter in the little cabinet by your desk marked the bin. Okay. When do you have to make an offer for financial settlement? Well, when you are directed by the court. You used to always be directed to make an offer before your financial dispute resolution hearing. However, this has sometimes been changed, and you may not be directed to make an offer until the final hearing. You may be directed to make a without prejudice offer, and in that case, you must ensure that you place the words without prejudice or without prejudice saved as to costs at the top of your letter in bold text. The effect of a without prejudice offer is that if the matter proceeds to the court, then the offer cannot be placed before the judge at the final hearing. As I said earlier, you can make an offer at any time in the proceedings. I often see people blindly send an offer in an attempt to avoid the court process, which I totally get. They will simply send an offer with a percentage share of the house and or other assets to see if the other party will bite. This, putting it kindly, is simply trying to fly a kite in adverse weather conditions. Your offer may in your eyes be generous. However, in reality, if you're going to make this type of offer, what is going to happen? I can tell you, it will either be ignored or rejected, and your kite will end up in bits on the floor. It's a blind offer without any of the relative information that you need, and is provided without any justification of how the offer meets the party's needs and why it is fair and reasonable. If you don't have all the facts, you will not know the other party's true financial position. You may hazard a guess, but you don't really know. You will almost certainly not truly know what their needs are, what their housing needs are, what their earning capacity is, and what their mortgage capacity is. Only when you have this information can you realistically know what share of the matrimonial pot your ex really needs, and therefore if your offer is indeed fair and reasonable. And only then will your offer have a reasonable chance of being accepted, or at least negotiated. Very few people, no matter how desperate, are willing to accept an unreasonable offer. Before you make your offer, you should do the best to get all their financial information and disclosures. You may not always have the complete picture in time to make your offer. There is a set format to use when making your offer, which is designed to show that you're taking all the key points into consideration. It justifies your offer, showing that it meets their needs and indeed is a fair and reasonable proposal. And most importantly, you should always provide two options rather than just one. You make one option which is probably not going to be that attractive for them, and a second option that you want them to accept. The objective is that it makes your second option look far more appealing. So, what should be in your offer? It should include a brief description of why you are making the offer. It may simply be the directions provided by the court. A summary of all the assets, including the family home, other properties, investments, pensions, and this should also include any valuations of the properties and the various assets, the income of both parties, any limitations on earning capacity, such as being the main carer for the children, the length of the marriage, the number of children, and the lifestyles the parties are accustomed to, the housing needs of both parties, and what the costs are of those houses in the areas that they are needed, the income needs of both parties, and then your proposal. And don't forget to present this in the form of option 1 and option 2. Each option should cover what should happen to the family home and to any other property, and the share that each party should receive from it, what the share of any pension should be, spousal maintenance if at all relevant, and debts. Who will be responsible for any debts? If there's to be a clean break, which is always recommended, it is not always possible. And finally, cost. You would normally just state there will be no order as to costs. And that's your highly effective offer proposal, which will hopefully be considered and taken very seriously. To make life easier for me when producing offers on behalf of my clients, I produced an offer template. And if you would like a copy of my offer template, then simply send me an email to Derek, which is DEREK, at McKenzie Friend Consultants with an s.co.uk. Or if you'd like assistance with your offer or simply discuss your case, then go to www.McKenzieFriendConsultants with an s.co.uk and book your free consultation with me. That's it for today, and if you find my short videos helpful, then please hit the subscribe button below. Bye for now, and until my next video.